May it please the court, my name is Stitt, initial MJ, and I appear on behalf of the defendant, Miss Walker. By way of antecedents, Miss Walker was born in Brisbane on the 8th of August 1994. She was 25 at the time she committed the offence and is 25 now. Miss Walker is currently unemployed, however she volunteers with the Movement for the Liberation of Animals, and she's currently in a stable relationship and lives with her boyfriend Harold Morgan at Spring Hill in Brisbane. In relation to her criminal history, we submit that it's relatively minor. It consists of 2 minor stealing offences and 1 offensive language charge from when she was 17 years old. 4 months later, she was charged with a further offensive language charge, and she received fines in relation to all of the charges. She has not committed another offence since, up until now. The defence relies on 1 comparable authority, the matter of CSN and the Queensland Police Service 2019 QDC 43. In this case, the appellant was a 39-year-old man who pleaded guilty to 1 charge of obstruct a police officer and was resentenced on appeal to 2 months imprisonment, suspended forthwith for an operational period of 2 months, backdated to the date of the original offence. The facts that were before the magistrate were that the police attended the appellant's residence to serve him with a notice, a police protection notice. The appellant became aggressive towards police, verbally abusing them when they began to explain to him the police protection notice before retreating to his room, closing the door. He then said words to the effect, "Kick down the door, you'll have to arrest me." Despite attempts from police, the defendant continued to barricade the door and verbally abuse them. The appellant then left his room and approached the police outside with his left hand behind his back. Police feared he may have been armed due to information that they had received and knowledge of his previous history. The defendant was not in fact armed, but retreated back to his room once the police produced a taser. After attempting to de-escalate the situation, police ended up calling for backup. Once the other police had arrived, they discovered that the appellant had fled. The appellant eventually returned to the property after calling a female resident at the property, stating that he was not going to be served with anything and that he was going to throw his phone away. On his return, he was confronted by police and continued to be abusive. He was eventually detained. The appellant has had a relevant criminal history, which included numerous assaults on police, intimidating police, and resisting officers in the execution of their duties. By way of sentence, while the case of CSN and the Queensland Police offers little way by factual similarity or guidance, I offer this case to the court as an example of a situation which would qualify for a custodial sentence. Miss Walker's case is not nearly as serious as the defendant in the matter of CSN and the Queensland Police Service. Therefore, the sentence which should be imposed for Miss Walker, we submit should be in the terms of a fine or a community service order. Miss Walker is not only significantly younger than the defendant in CSN and the Queensland Police Service, but she also has no history of violence. She instructs that she suspects witnessing thousands of sheep being herded into undersized pens earlier that day was a contributing factor which caused her to lose control on the day of the offence. She instructs that she became very upset witnessing such events, and she went and had a couple of beers to help her calm down before rejoining the demonstration. On Miss Walker's instructions, the demonstration was orderly, and she was just holding a place card when she noticed that the police were taking her boyfriend away. She claims that seeing that made her very upset, and that was because she didn't believe he'd done anything wrong, and she does admit to trying to pull him away from the police. It is our submission that the defendant's plea of guilty is an early one, and it should therefore be taken into consideration. The maximum penalty for obstructing an officer in performance of their duties in the vicinity of licensed premises is 60 penalty units or 12 months imprisonment. Section 9 of the Penalties and Sentences Act states that the court must impose a sentence which punishes the offender as well as deters them and any other persons from committing such an act. We submit that's also necessary for the court to impose a sentence which makes it clear to the community that this type of behaviour against our police officers is denounced. However, in saying that, a sentence of imprisonment should be taken as a last resort, especially in a situation like this, where the defendant is young, doesn't have a relevant criminal history, still has a whole life ahead of her. The offending wasn't as serious as it could have been, and the Penalties and Sentences Act does promote a sentence allowing the offender to stay in the community if possible. As Ms. Walker's case is at the lower end of the spectrum, we therefore submit that a fine or anything less than $6,600 would be deemed as appropriate. However, as Ms. Walker is unemployed, she may not be able to pay such a substantial fine. It would therefore be our submission that a community service order may be more appropriate in the circumstances. Unless Your Honour requires anything else, those are the submissions on behalf of the defendant.